Zainal Sapari.
Mr. Speaker, I support the proposed amendments to the Work Injury Compensation Bill. Overall, the proposed amendments will essentially make the bill more worker-centric. I would like to focus my speech to share my perspective of this bill in relation to the vulnerable, low-wage and foreign workers. Extending compensation under WICA to include those on light duties due to work injury is a positive change towards covering the potential loss in workers' income because they may not be able to continue to work overtime given the highly manual and strenuous nature of their work and hence losing out on overtime payment or other incentive. For many low-wage workers, a sizable portion of their pay package comprises of overtime payment, allowances and incentive payments while doing their regular work. More importantly, it also prevents the occurrence of possible abuse of the system where the injured vulnerable worker may be given medical leave for less than the stipulated 4 days as a way to get around the duty to report for WICA, and the remaining recovery period is covered by light duties. Such circumventing measures may arise as company-approved medical practitioners may face the dilemma of balancing their financial interests against their ethical obligation when it comes to prescribing appropriate duration of medical leave for the workers. The Employment Act has been amended to make it mandatory for employers to issue pay slips. However, in WICA cases assisted by Migrant Workers Centre involving many work permit holders, especially on the lower end of the skills profile, they continue to be paid in cash without the issuance of any records. Thus, NTUC welcomed the proposed amendment that allows MOM to order compensation based on a multiple of the worker's basic monthly salary or the average monthly earnings based on at least 75% of cases of the industry norms. This will benefit the low-wage and migrant worker sectors where the absence of pay slip tend to be more prevalent. NTUC also support the move for initial compensation based on current incapacity or CI assessment at 6 months after the work accident to allow for faster claim resolution for workers. In fact, this makes the WICA to be more worker-centric and responsive to the specific needs and situation for the migrant workers as it levels the playing ground for migrant worker claimants and even up the odds in favor of workers. MWC had encountered cases involving injured foreign workers who were required to stay in Singapore for extended claims but not allowed to work and inevitably run into difficulty with upkeeping and maintaining themselves. There are good reasons to suspect that some employers or insurers may deliberately drag the cases because they are aware the migrant worker will run into hardship and put the employers or insurers at an advantage to negotiate a lower quantum which the worker has little choice but to accept, or even hold out on payment against which the worker has no means, whether in terms of time or money, to enforce. Currently, all employers are required to have compulsory medical insurance for their migrant workers, but most employers will only ensure minimum medical insurance coverage for their migrant workers to meet MOM's requirement. As our laws require the employers to be liable for the medical treatment for the foreign workers, some employers will incur huge medical expenses for their injured migrant worker if the WICA cases drag for too long, since all foreigners are charged unsubsidized rates for treatment and hospital stay. As such, having a safety net provision for CI assessment at 6 months will benefit workers and employers as well, because WICA is also meant to cover medical treatment costs for claimants or at least help to defray costs of treatment which for migrant workers are liable to be borne by employers. Hence, the increased WICA coverage for treatment, together with expedited claim payout, will certainly help in cases where urgent medical treatment is needed by the worker, but the employer is unable to pay due to lack of medical insurance coverage or other cost issues. Another issue arising from claims processing times is the situation where employers do not provide accommodation or maintenance for their claimant workers anymore, or the worker himself wishes to leave his employer's hold given the breakdown in their relationship for whatever reasons. The migrant workers who decide to stay on pending the outcome of their injury claims are generally prohibited from working, which may cause them a lot of financial hardship. Situation where the injured migrant workers opt to stay on their own and unable to work legally to support their own maintenance and upkeep is undesirable given the potential for them to moonlight illegally, which will deny them of all the employment protection. Some may succumb to antisocial or even criminal behavior in a bid to survive, which is detrimental to our society's well-being and safety. Thus, expediting the claim processing time will minimize the cost of their maintenance and upkeep and perhaps lessen the likelihood of the migrant workers facing financial hardship and having to resort to undesirable action that would be detrimental to themselves and our society. Given the changes made to WICA, there is a need to raise workers' awareness through outreach efforts, especially among the vulnerable, low-wage and migrant workers. Many vulnerable workers are still unaware of the basic provisions under WICA, like how you could still claim under common law even after filing for WICA, but cannot do so in the reverse. Some injured, vulnerable workers may file injury claim under common law at the advice of overzealous lawyers without realizing that they are signing away their rights to a WICA claim. They might also be unaware of how WICA differs from legal suit under common law in compensation quantum and other aspects like standards of proof and others. There must also be concerted efforts to change the mindset of employers to see WICA as an extension of the company's work safety, health, worksite culture, where employers are themselves briefed extensively in WSH and WICA laws, and these aspects are refreshed regularly in worksite safety briefings and meetings. Such efforts will result in a general leveling up of the understanding of WSH and WICA for both employers and their workers, and thus minimizing potential costs for misunderstanding and disputes. While the migrant worker will face a shorter waiting time for their claim processing and can return to their home country earlier, I would like to inquire on the channels that would be made available for workers to seek reassessment in the event their injury condition deteriorates after the 6-month mark. Ideally, such established channels must be guided by MOM and not by employers or insurance companies who might make it too onerous for workers seeking reassessment. Some occupational diseases or ODs can be undiagnosed for a prolonged period. For example, symptoms of habitosis may occur 20 years after exposure, but given WICA's current 1-year time bar, it would exclude such OD with long latency periods. How can workers be compensated for such work-related injury or diseases? As our government is also encouraging older workers to work, would the standard WICA insurance clauses be inclusive to ensure employers can buy insurance coverage for all their workers? Since older workers are sometimes prone to injuries due to slips and falls, some insurance companies may have exclusion clauses in fine print to exclude coverage for older workers. Under the proposed amendment, MOM licensed insurers will assess and process all WICA claims as per stipulated MOM guidelines and time standard. This will lead to more expeditious claim processing, but will check and balances by MOM to ensure fairness to all parties. In the past, where MOM processed the claims and perceived to be the guardian of fairness of the WICA claim, however, outsourcing this function to MOM licensed insurers may lead to the judgment being questioned in terms of fairness, as the insurance companies have a vested interest to keep compensation on the low side. In addition, insurance companies may also try to keep premiums low for their policies to be competitive, but at the expense of being unable to have sufficient financial standing to give our workers adequate and fair compensation. To mitigate this, NTUC welcomed the system of controls and penalties to accompany this legal innovation to ensure insurers remain on-site, fair and objective in their assessment. How effective this new licensing and enforcement regime can only be reassessed after the new system has been in place for some time. In the meantime, the Union and MWC will continue to get a better ground sensing when we help our workers in the claims under WICA. Nevertheless, we urge the policy makers to review the application of the new insurer process system at appropriate juncture so that further review and strengthening may continue to be made to it along the way to more effectively safeguard the rights and welfare of the key intended beneficiaries of the Act. Mr. Speaker, in Malay, NTUC menyokong pindaan kepada Akta Pampasan Kecederaan di Tempat Kerja kerana ia memberi perlindungan yang lebih baik kepada pekerja-pekerja yang mengalami kecederaan sewaktu bekerja. Pindaan ini mengusulkan hak pampasan yang lebih tinggi dan akan merangkumi lebih ramai pekerja. Selain itu, pindaan ini juga memastikan perlindungan insurans yang lebih mantap dengan pengecualian terhad untuk memastikan pihak majikan dan pekerja boleh membuat rayuan untuk mendapatkan pampasan bagi kebanyakan kecederaan yang biasa menimpa para pekerja. Walaupun tanggungjawab untuk memproses rayuan pampasan di bawah akta ini diberi kepada syarikat insurans yang dilantik oleh MOM, pindaan ini masih membolehkan pekerja mempertikaikan pampasan yang diberi jika perlu. Bagi pihak majikan, pindaan ini juga membantu mengurangkan kos membeli insurans WICA yang akan menjadi lebih rendah jika mereka mempunyai rekod keselamatan yang baik di mana tidak ramai pekerja mereka mengalami kecederaan sewaktu bekerja. WICA adalah akta yang amat baik untuk pekerja, tetapi amatlah penting untuk pihak kementerian mengambil langkah untuk meningkatkan kesedaran para pekerja tentang akta ini, terutama sekali mereka yang bergaji rendah dan kurang berpendidikan. Ini akan mengelakkan majikan yang tidak bertanggungjawab daripada mengambil kesempatan untuk menipu pekerja-pekerja yang cedera agar mereka tidak membuat rayuan untuk mendapat pampasan daripada WICA yang boleh menjejas rekod kemalangan syarikat itu. Mr. Speaker, in conclusion, I believe that we are indeed making a big step in the right direction for our workers here in Singapore. The proposed amendments show that we understand the urgency of workplace compensation and the need to be fair and transparent to all parties involved. Thank you.